My brother looked the arbitrator dead in the eye and said, "She didn't build that company, she answered phones." I didn't move. I had spent 22 years building Caldwell Brace Consulting from a 2-person operation out of a rented office in Cincinnati into a firm with clients in 11 states, and the man sitting 3 feet from me, my brother, Owen Merritt, who had borrowed money from me 4 separate times and never paid back a dime, was telling a certified arbitrator that my role in our father's company had been clerical. The arbitrator, a woman named Doris Fenn, made a note on her legal pad. She didn't look up. My father, Leonard Merritt, died in March. He left behind a business he'd started in 1987, a house in Dayton he'd lived in for 31 years, and a will that divided his estate equally between Owen and me. Equal. That was the word his attorney used when he called to read us the summary. I remember standing in my kitchen holding the phone, thinking that equal sounded right. It sounded like something my father would have wanted. What I didn't know then was that Owen had already been to see a different attorney, his own attorney, one who specialized in contesting estates. My father's business, Merritt Structural, was a civil engineering consulting firm. When he started it, he had one client, a county road project in southwestern Ohio. When I joined the firm in 2001, fresh out of Ohio State with an engineering degree and a minor in business administration, we had 4 employees and a waiting list of 2. By the time my father stepped back from day-to-day operations in 2019, we had 31 employees, contracts with 6 municipalities, and a revenue line that had grown by nearly 400% over 18 years. I ran the firm for those last 6 years. I was the one who restructured the billing system. I was the one who hired our current project director, a man named Cal Briggs who is worth every dollar we pay him. I was the one who flew to Columbus in 2017 and spent 3 days in meetings with the Ohio Department of Transportation until we landed the contract that doubled our annual revenue in a single year. Owen worked for the firm for approximately 4 of those years. He was a project coordinator, which is not a small job, but it is also not the job of the person who runs a company. He left in 2015 to pursue a real estate venture that did not work out, and after that he occasionally consulted for us on specific projects, for which he was paid his consulting rate, the same rate we would have paid anyone. The will divided the estate equally. What Owen was now arguing, through his attorney, a man named Roger Taft who wore a suit that cost more than my first car, was that equal division was not equitable, because the business had been my father's creation, not mine, and therefore the increase in its value during my tenure had been incidental to his legacy, not the result of my labor. He was arguing in plain language that I had been an employee, not a co-builder. He was arguing that I should be bought out of the business at a valuation that reflected what an employee's contribution would be worth, not what a co-owner's would be. It was, his attorney said during the opening statement, a matter of fairness to the founder's full legacy. I remember thinking, Owen wouldn't know a full legacy if it filed quarterly taxes and kept him employed for 6 years. The arbitration had been my idea, actually. When Owen first raised his objection to the will's execution, I pushed for arbitration over litigation because I thought it would be faster, less adversarial, and cheaper for both of us. I still thought we might work it out. I still thought that somewhere underneath the legal filings and the careful language of his attorney, my brother understood what I had done for our father's company, and was maybe, possibly, having some kind of temporary failure of gratitude that we could get past. What I did not yet understand was that Owen had been telling this story for years, not just to lawyers, to our relatives, to people at our father's church, to anyone who had known our family and would listen to a version of events in which I had swooped in on our father's success and leveraged my position as the favorite child to claim credit for work that wasn't mine. I found this out the hard way, the way you find most things out when family is involved. Too late, and from a stranger. Her name was Pamela Shores. She was my father's longtime administrative coordinator, had been with the firm since 2004, and she pulled me aside at my father's memorial reception and told me quietly, with the particular discomfort of someone delivering information they wish they didn't have, that Owen had called her twice in the month before my father died, that he had asked her questions, specific questions, about billing records, about whose name was on what correspondence, about which contracts had originated from our father's personal relationships and which ones had come through channels I had developed. She said she had answered him honestly. She also said she had felt, both times, that the questions were not entirely innocent. I nodded. I thanked her. I went home and spent 4 hours going through the company's files. I want to be clear about something, because it matters to what came next. I was not angry in the way people expect when they hear a story like this. I have been asked, since then, whether I was furious, whether I wanted to confront Owen immediately, whether I cried. The answer to all of those is that I was something closer to tired. Deeply, specifically tired, in the way that you get tired when something you have been quietly suspecting turns out to be real. The anger came later. First came the clarity. I called my attorney, a woman named Janet Cawley, who I had worked with on contract negotiations for years, and I told her what Pamela had told me. Janet listened without interrupting, which is one of the things I appreciate most about her. When I finished, she said, "Okay, tell me what you kept." What I kept was everything. I am, by training and by temperament, a person who documents. My father was the same way. He used to say that the difference between a good engineer and a great one was that the great one could prove every decision she ever made. I had emails. I had meeting notes. I had copies of proposals in my own drafts folder going back to 2003. I had the original pitch deck for the ODOT contract. I had my name on the application for our firm's state certification renewal in 2016 and 2018 and 2022. I had performance reviews that I had written for every employee who had ever worked for us, signed and dated and stored in personnel files that were legally the property of the company, and therefore subject to discovery. What I also had, and this turned out to matter more than any of it, was a relationship with a man named Dr. Garrison Webb. Dr. Webb was a professor of civil engineering at Ohio State. He had been my academic advisor. He had also, independently of that relationship, served as an expert consultant on two of our largest municipal contracts, hired through a formal consulting agreement, paid through the firm's accounts payable, with a scope of work that clearly delineated what he was providing and who had brought him in. He had not been brought in by my father. He had been brought in by me in 2014, because I had identified a gap in our technical capacity for geotechnical analysis, and he was the best person I knew to fill it. Dr. Webb was 71 years old. He had been retired from his faculty position for 4 years. He had no stake in the outcome of our arbitration. He had no reason to testify on my behalf except that Janet asked him to, and he agreed, because, as he told her, he believed in accuracy. He appeared via video conference, because he had recently had knee surgery, and his doctor had advised against travel. He was sitting at a desk that was covered in papers and books, the kind of organized chaos that belongs to a person who has spent decades inside a particular subject and stopped apologizing for it. He looked exactly like what he was. Someone who had no interest in being anywhere except where the facts were. Owen's attorney, Roger Taft, went first. He was polite to Dr. Webb in the careful way that attorneys are polite to witnesses they intend to undermine. He asked about the consulting relationship. He asked whether it was unusual for an engineering firm to bring in outside expertise. He asked whether Dr. Webb had had prior relationships with the Merritt family before I retained him. Dr. Webb said that he had known me since I was a sophomore in his Introduction to Structural Systems course in 1999. He said that he had written a letter of recommendation for my first professional position after graduation. He said that when I called him in 2014 about the consulting work, his first reaction had been that he was glad someone had finally thought to ask him. Roger Taft asked whether that prior relationship might color his recollection of events. Dr. Webb looked at the camera for a moment before answering. He said, "I'm a scientist. I have records. Would you like to see them?" He had brought to his end of the video call a folder. Inside the folder were printed copies of the emails I had sent him in 2014 outlining the scope of the engagement. He read from one of them. Not much, just the opening paragraph, where I had laid out the gap in our capacity, the specific contract we were targeting, and the technical requirements we needed to meet. He read it the way a professor reads a student's work when he wants to make a point, carefully and without rushing. The arbitrator asked to have the emails entered as supporting documentation. Roger Taft said he had no objection, in the tone of someone who very much objected but understood that objecting would make things worse. My brother was sitting to my left, at a slight angle, and I had spent enough of my childhood in the same room with him to know his tells. He had a habit, when he was uncomfortable, of picking at the edge of his thumbnail with his index finger. He was doing it now. I did not look at him directly. I looked at Dr. Webb's face on the screen, and I thought about the meeting in 2014, where I had convinced our father to bring in outside technical support for the first time in the company's history. My father had resisted, not because he disagreed with my reasoning, but because he had always believed that a firm's value was in what its own people could do. I had argued that knowing what you needed and finding the right person to provide it was itself a kind of expertise. He had thought about it for a long time, sitting at the head of the conference table with his hands folded, and then he had said, "All right, Your call. That had been his phrase. Your call. He used it when he trusted someone enough to let them lead. Owen's attorney called 3 additional witnesses. A former client, a man named Gerald Phipps who had worked with our firm before my tenure and remained a client after, testified that the firm's culture and approach had always felt consistent to him, which was meant to imply that nothing had changed when I took over. Janet cross-examined him for 12 minutes and established that he had last visited the firm's offices in 2013, that he communicated primarily by email and had not met me in person more than twice, and that he was aware of the ODOT contract only because he had read about it in an industry newsletter. A former employee, a project manager named Dave Kellner, who had left the firm in 2017 under circumstances that were not entirely amicable. He had been passed over for a promotion that went to someone I had brought in from outside, testified that the firm's strategic direction had been set primarily by my father during the years he worked there. This was true. For the years he worked there. Janet asked him when he had last spoken to anyone at the firm. He said 2018. She asked whether he had any direct knowledge of the firm's operations after that date. He said no. The third witness was Owen himself. He was prepared. I will give him that. He had clearly spent time with his attorney going over what to say and how to say it, and he had the practiced composure of someone who has rehearsed a version of events until it feels true. He talked about our father's vision. He talked about the relationships our father had built over decades in the industry. He talked about the way clients had trusted the Merit name, and how that trust had been the foundation on which the firm's growth was built. He was not wrong about any of that. That was the thing that made it hard to sit through. Our father had built something real, and the foundation Owen described was real, and Owen was using real things to build a false conclusion. When Janet cross-examined him, she asked a single question first. Can you tell me the name of the project manager who led the ODOT contract negotiation? Owen said he believed it had been a collaborative effort. Janet asked again specifically, who led it? Owen said he wasn't sure of the specific details. Janet put a document in front of him. It was the contract execution memo, the one filed with ODOT upon signing, the one that listed the firm's point of contact for all project communications. My name was on it. My signature was on the signature line above the words principal in charge. Owen looked at it for a moment. He said, Dad signed off on everything. Janet said he did, after your sister brought it to him. Is that your understanding? Owen said he wasn't present for every internal conversation. I had not planned to speak during the arbitration beyond my own testimony. Janet had advised me to stay measured, to let the documents do the work, to avoid anything that looked like personal grievance because personal grievance, in a room like this, can look like instability. I had agreed with her reasoning. I had spent 2 months agreeing with her reasoning. But there was a moment, about 40 minutes into Owen's testimony, when he said something that I had not expected and that Janet had not prepared me for. He said that our father, in the last year of his life, had expressed to him privately that he worried I had lost sight of the company's original values. That I had become, in his word, corporate. That the firm he had built was becoming something he didn't entirely recognize. The room was quiet for a moment after he said it. Not dramatic quiet, just the ordinary quiet of a room waiting to see what happened next. What I thought in that quiet was this. My father ate dinner at my house 11 times in the last 18 months of his life. He came to my daughter's middle school science fair. He called me every Sunday afternoon. He told me, 4 weeks before he died, sitting in the passenger seat of my car in the parking lot of his cardiologist's office, that he was proud of what we had built together and that he hoped I knew he meant both of us. I had that conversation on my phone. A voicemail he left me 2 days after, reiterating what he'd said in the car because this was my father. He worried he hadn't been clear enough the first time. Janet had it too. She had asked me, early in our preparation, to go through every piece of communication I had from my father in the last 2 years of his life. I had sent her 43 texts, 11 voicemails, and a card he had written to me on the occasion of the firm's 30th anniversary, which he had mailed because he believed that some things should be on paper. The card was already in evidence. Janet had entered it during my testimony, along with the voicemail transcript. When Owen finished his statement about my father's private concerns, she asked the arbitrator's permission to play a portion of the voicemail. The arbitrator said yes. My father's voice came through the speaker. He had a particular voice, low and deliberate, the voice of a man who had spent decades in rooms where precision mattered. He said my name. He said he wanted to make sure he had been clear. He said that what we had built together was the thing he was most proud of professionally, and that he knew the firm was in the right hands. He used those words, the right hands. The room was quiet again after the recording ended, a different kind of quiet this time. Owen's attorney asked for a short recess. The arbitrator granted 15 minutes. I went to the hallway and stood by a window that looked out over a parking structure. Janet came and stood next to me and didn't say anything, which was the right choice. After a while she said, "You okay?" I said I was fine. She said, "You are doing great." I said I knew. What I didn't tell her was that I had listened to that voicemail probably 60 times since my father died. That I had listened to it the night before Owen filed his objection and 3 times the morning of the arbitration. That I had memorized every pause in it, every small roughness in my father's voice from the medication he had been on, every place where he stopped and started again because he wanted to get it right. He had worried he hadn't been clear enough. He had always worried about that. When we reconvened, Roger Taft informed the arbitrator that his client wished to make a clarifying statement. The arbitrator permitted it. Owen looked at his hands for a moment and then said, in a voice that had lost its earlier steadiness, that he wanted to acknowledge that his sister had contributed significantly to the firm's growth, and that his intention had never been to diminish that contribution. It was not an apology. It was the thing adjacent to an apology that people offer when they want the record to show something different from what they have spent 3 months doing. But Roger Taft followed it with a brief statement that his client was prepared to discuss a resolution consistent with the original terms of the will. The arbitrator looked at both of us. She said, "I'll be making my recommendation in writing within 30 days. In the meantime, I strongly encourage the parties to use this moment productively." We settled 2 weeks later. The terms were consistent with the original will, equal. My brother and I have not had a real conversation since. We exchanged texts about logistics. Our father's house is still being processed through the estate, and the texts are polite and functional. The way texts are when 2 people have agreed, without saying so, that politeness is the most they can manage right now. Maybe that changes, I don't know. What I know is that I drove back to the office after the settlement was signed, and I sat in my father's old chair, which I had moved into the conference room, because his desk chair was too important to throw away but too complicated to sit in every day, and I thought about what he used to say about documentation. He used to say, "If you did the work, prove it," not to anyone in particular. Just prove it. Keep the records, keep the emails, keep the notes from the meetings where you made the decisions that turned out to matter, not because you expect to need them. Because doing the work and being able to show the work are not the same thing, and the second one is what protects you when someone decides the first one didn't happen. I had done both. That was the thing I kept coming back to, in the days after. I had done the work, and I had kept the proof, and when it mattered, the proof was enough. Pamela Shores still works for us. She got a small raise last year, which I authorized because she has been with the firm for 20 years, and because accuracy, as Dr. Webb would say, deserves recognition. Cal Briggs ran 3 new municipal pitches last quarter. We won 2 of them. The chair is still in the conference room. Sometimes, when I'm in there for a long meeting, I look at it and think about my father sitting in it, hands folded, listening to me make the case for something he wasn't sure about yet. Thinking it over, taking his time, and then saying, "Your call."